Welcome, welcome, welcome. We're doing a live recording here, and welcome to the webinar. We're talking today about what do you do when your spouse or another loved one dies? So, what are the first things that you need to do? So, welcome everyone. I'm San Diego Trust and Estate Attorney Kristina Hess, and I'm thrilled to be bringing you this webinar today. We're going to record it. It will be on YouTube. So if you haven't subscribed to our YouTube channel, be sure to do that. We're going to be putting 1 or 2 educational videos a month up there for clients. And this one was asked by one of my clients, can you do a video? What do we do if someone passes away? So real quick, I grew up in San Diego, went to Berkely Law School, been an attorney for over 24 years and opened San Diego and now Salt Lake City estate planning firm and trust administration and probate firm Hess Law in 2009. And I'm also a certified specialist in estate planning, trust, and probate law. Okay, so my disclaimer, I'm not your lawyer unless I am, and you've signed an attorney-client agreement. So this webinar today is for informational purposes only. So we hope you get some good value and learn some things today. So if you're in a situation where your loved one has passed away, first of all, my most sincere condolences. I know how difficult it is. I haven't lost a spouse, thankfully, but I've heard from clients that you're really like in a numb, you're in a fog, it's just a really incredibly difficult situation. I know for me, my own father passed away suddenly. He was on a fishing boat in Alaska, here one day, gone the next. It was very sudden, unexpected. I was his successor trustee, and so I had to manage his trust and estate. Fortunately, he had a trust, but there were some things that weren't necessarily set up correctly. So the first thing that you want to do, besides taking care of yourself and the immediate arrangements with the memorial and the funeral and all of that, I mean, obviously those are the immediate steps that you have to take. And a lot of the memorial services and funeral homes will help you with ordering death certificates and things like that. But the first thing that you want to do is gather the estate documents. If it's your spouse, then hopefully you know whether they had a will or a trust or both and what estate documents they had in place. And then you want to also start gathering the asset information, real estate, stocks, bonds, brokerage accounts, personal property, cash, where there are partnerships or business entities, LLCs. And sometimes, if, for example, it's a sibling or a friend or a loved one who's passed away, you might not know the universe of assets. So all of our clients, we do in wealth inventory. So we get information from them and we really try to list all of the assets in one place on one inventory. But if the person who passed away hasn't done any planning, that might not be the case. And then nowadays, with so many online accounts and online benefits and online savings and CDs, it can become more challenging because people don't get paper statements. So a lot of times they'll say, well, go through their mail or go through their personal effects. Yes, do all of that. If you're the next of kin, if you're the spouse, or you're nominated in their will as the executor or in their trust as the successor trustee, then you have legal authority. If you're a friend or a sibling, or there might be potential heirs, then you're going to need to, if they don't have it clearly designated in legal documents, you'll want to get court authorization to be the administrator. So we'll talk a little bit about that. But the first step is just gathering information. If they had a plan in place, the digital assets, now there are digital asset laws that will allow you to access those things. If not, sometimes we have to get a court order, which is expensive and quite time consuming. So that's step number one, is you want to gather the universe of documents and estate documents. And then the next thing are immediate notifications. So there's some things that are auto deposited. Usually if the person was over 65 or over 70 and they were retired, they're getting Social Security, you want to call them right away, because if payments are made in the month after the death, you're going to have to reimburse the Social Security Administration. Same thing with pension or other benefits. It's possible that they have survivor benefits, but they might not. So you're going to need to look into anything that's auto deposited or benefits on death that might cease, or you may be able to apply for survivor benefits. And then you'll also want to research additional employer benefits, 401k plans, pensions, stock benefits. You just want to get the universe of anything that's immediately transferred that you might have to reimburse if the auto deposits are not stopped. So that would be an immediate notification. Then there's other time periods of statutory notifications that you'll want to be mindful of. So oftentimes people will say, you just lost a spouse or a loved one, don't make any major decisions right away. Which, when it comes to where you're going to live or like key life decisions, that's good advice. When it comes to estate administration, you have to be mindful that you might still be dealing with a lot of grief and you might feel like you're in a fog, but there's statutory time periods that are pretty quick. So the original will should be lodged with the probate court in California within 30 days of death. Within 60 days, the successor trustee needs to notify the heirs and the trust beneficiaries. If there's not a trust, then this particular deadline will not apply. But if there is a trust, you not only have to notify the trust beneficiaries, but you have to notify any other heirs at law. So sometimes people will leave assets, disinherit certain people, but they still have to get notice of the administration in California. The county assessor for real property wants notification of death. There's a death of ownership report. And then once you notify trust beneficiaries, you'll want to send a copy of the trust because that starts the clock. Because once they get notice of the administration, they have 120 days to challenge the trust. So if you send them notice within 60 days, but you do not include the trust, and then they come back on day 119 and say, oh, can I have a copy of the trust? They get an additional 60 days. So that's important because oftentimes you don't want the trust administration to be held up. You want to make sure that you're moving things along quickly. 90 days, the Department of Health and Human Services, if there were Medi-Cal or other benefits paid. And then if any beneficiary asks for a trust accounting. So California recently changed the law. They recently changed the law that if soon as the trust becomes irrevocable, so most revocable living trusts, when the grantor dies, the trust becomes irrevocable. Now, if you're married and it's a joint trust and it goes to the survivor, usually that's not irrevocable. The survivor can still amend, revoke, change the document. If the trust splits at the first death, so half of it goes to a survivor's trust and half of it goes to a marital or a bypass trust, those sub-trusts are irrevocable. So there is an accounting requirement. So if a beneficiary requests an accounting, there's a 60-day time period to provide that. So those are just some of the time periods to keep in mind so that you don't go, oh, I have all this time. I have a year, or I have time to make all these decisions. Unfortunately, some of these things need to be addressed right away. And then if you're married, there's a 9-month deadline for the ability to file portability. So what is portability? And this is really like insurance. This is a big deal. Now, if you die, there's a $13.6 million estate tax exclusion amount in 2024. So if your spouse dies this year or next year before the sunset, on 12/31, those numbers are going to be cut in half. But if they died now and you think that in the future you could potentially have a taxable estate, you can save your deceased spouse's unused estate exemption. So you could save that 13.6 million. Or if they've done any lifetime gifting, it would be 13.6 minus any lifetime gifts they've made, but you can save it for when you die, or you can save it and file portability on an estate tax return 706, and that needs to be done within 9 months. You can get an extension for 6 months, and the portability part of it, not the estate tax return, but the portability part of it, you can get up to 2 years or up to 5 years, depending on the circumstances. The 706 estate tax return, though, if there is a taxable estate, is due within 9 months of death. So these are just some of the time periods that you should really discuss with an estate attorney. Hey, there's a will, or there's a trust, or there's no trust, or what time periods do I need to be mindful of in my particular situation? My loved one has just died, or my spouse has just died. So the next big question, and the segue here, is what type of administration is needed? So if there's a trust, like let's just take my dad's example for for discussion. So he had a trust. So he had a trust. His real estate was titled to his trust, thankfully. So it was a trust administration. He didn't necessarily have anything that would pass through probate. So he had a trust. The person in charge is called the successor trustee. So that's the person who is tasked with administering the trust. So that's the first step. Is there a trust? And then the second question is, was the trust funded? Were the assets actually titled to the trust? So this is where you're going to look at, and this is where an attorney can be really helpful. A lot of people will go to the estate or trust attorney that drafted their loved one's trust or their parents' trust. That's great, but then sometimes people say, oh, they retired, or oh, they're not in business anymore, or oh, I didn't like that person, or oh, they wanted to charge me $20,000. So you can go to any attorney, but you'll just need to bring the trust and estate documents and fill out an asset inventory to the extent that you've identified the assets. Okay, so we get the documents, we get the trust, we read the trust, we figure out who's the successor trustee. They're the ones in charge of administering the trust. And then we want to look at the assets. Was the trust funded? Are the assets titled to the trust? If they are, that's the best case scenario. So most of our clients, they're going to have everything funded. Real estate accounts, stocks, bonds, bank accounts. You'll want to make sure that those things are funded. If they're funded, then we proceed with the trust administration. You notify the beneficiaries. The trustee will be tasked with valuing and potentially liquidating the assets. Now, if you're a survivor's spouse, you'll want to say, what type of trust was it? Does everything go to me in a survivor's trust and the trust just keeps going? Or does the trust divide at the first death? If it divides, you might want to say, how long ago was the trust drafted? Was it drafted pre-2013? Because if it was drafted before 2013, a lot of attorneys before that time period were doing what are called A-B trusts, where there was a mandatory split at the first death. And you might be a surviving spouse and you might be saying, I don't know what kind of trust I had. I hear that a lot. And then we look at the trust and lo and behold, it says, oh, half of the assets go to an A trust or a survivor trust and half go to a B trust or a decedent trust. In today's estate tax environment, unless your assets were over $15 or $20 million, chances are if you had an older AB trust, you do not want to fund the B trust because those assets do not get a step up in cost basis. So I'm not going to go into the details of what that means because it's beyond the scope of this webinar, but just know, have an attorney look at the trust, make sure the trust, you have to follow the terms of the trust. If there's a mandatory AB clause, you can't just ignore it and say, well, we're not going to fund the B trust because we don't want our kids or our secondary beneficiaries to pay capital gains tax. You can't do that. So you're going to want to look at the trust, have an attorney look at the trust, and then you'll go through the steps of trust administration. You'll want to make sure that if there is a surviving spouse and there's a marital trust or a Q-tip trust, that the election needs to be made. Those are made on the 706 estate tax return. So these are important things that you'll want to work with the CPA. I usually say the team is the trust and estate attorney, the wealth managers and financial advisors, and your CPA. So that's the team, and we all work together and coordinate and make sure that we're all on the same page for making sure the tax returns get done, the asset management changes get made. So that's the team of people that you want. If you already have a great team, wonderful. And so that's the trust administration. So that's the first one. And honestly, this is the ideal. This is where everyone wants to get. And if you don't currently have a trust, and your loved ones would have to go through probate when you die, then that's step number one, get a trust. If you're past that and your spouse or your loved one died, then you want to make sure that if they had a trust. If they didn't have a trust, then we're talking about probate court. Okay, so step number two is this a probate administration? A probate administration, when is that going to happen? So that's going to happen if the decedent just left a will. So years ago, I had a client come to me and her mom had passed away and she had a house in North County and she said, Mom died, but she had a will. And I said, well, that's great, but did she have real estate or did she have assets? At that time, it was over 150,000. And she said she had a house. And so I said, well, unfortunately, I hate to be the bearer of bad news. It's great that she had a will saying who the executor was and who the beneficiaries are. That's great, but a will has to go through probate. There's no avoiding a will going through probate if the asset threshold is met. So what's the threshold? It's real estate. So any real estate over, I think, $50,000 has to go through some form of probate. Or if there was cumulative assets in California over 184,500. So that would be if there was bank accounts, stock accounts, bonds, something that was titled in the decedent's name that did not have beneficiaries. In Utah, the threshold is $100,000. So if there was real estate or assets over 100,000 in the state of Utah, then you would have to go through probate. So a will guarantees probate because probate comes from the Latin derivative to prove. So we want to prove the validity or the original, that it is the original will. Number two is the court has to make sure that the creditors get paid. So we like to joke that probate's a lawsuit you file against yourself with your own money when you're dead for the benefit of your creditors. It's not a good use of resources, but nevertheless, it's required by law if the asset thresholds are met and there's only a will and there's no trust or beneficiary. So we'll talk about beneficiaries on the next slide. So the will guarantees probate. They identify and inventory all of the decedent's property. The court in California will assign a probate referee who's going to appraise the property. We give notice in the newspaper to all creditors, and then any known creditors you need to send notice to, and then the executor or the administrator of the estate will make sure that the debts and the taxes are paid. And then finally, once all that is done, then the distribution, there'll be a final petition submitted to the court for distribution to the heirs or other beneficiaries, and then the administrator can close out the estate. How long does it take? We'd love for it to happen in less than a year, but realistically, it could take months, a year, 2 years, if no one contests anything. If people start challenging the will or challenging the sale of the house or challenging different aspects of the administration, it could take longer. So that's a probate administration and when that is appropriate. The next possibility is you've got assets that the decedent left that are going to pass outside of the will or the trust. So what would this be? If the decedent held property in joint tenancies. So sometimes people will have, I have a case right now where sadly the son died and he had a trust, but then he also owned property jointly with his brother. So they were joint tenants. So that if it says joint tenants with right of survivorship, then it could go to the surviving joint tenant. Now, if people were married and it was joint tenancy, then there's a whole nother rule in California that could come into play. So you'll definitely want to talk to an attorney before you just transfer property there. Jointly held assets. So this would be like joint bank accounts. So if you have a bank account, I don't recommend putting your kids on your accounts for liability reasons. If they get sued, your money could be taken. I've had cases where a mom put her son on a bank account and the son decided to borrow $40,000 without mom's permission. So I don't recommend that. It puts your assets at risk. Having the assets in trust with your child as a co-trustee is a much better solution. Assets with named beneficiaries, so life insurance. If you have a trust, you'll either have a life insurance trust for tax planning, or if it's just if you don't have a taxable estate, then your life insurance, most likely you want your revocable trust to be the beneficiary. But life insurance is going to pass to who's listed as a beneficiary on file with the life insurance company. So that's not going to go through the trust or probate unless there's no beneficiary, and then it goes to the estate. Anything that goes to the estate goes to probate. If it goes to the trust, then again, that's going to pass through the trust administration. But if there's just individuals listed as the beneficiaries, they would then directly collect the life insurance from the carrier, so, or the insurance company. So if it's New York Life or Prudential or Guardian, they will just apply for the benefits directly. Same thing with IRAs, 401ks, retirement plans, and annuities. If individuals are listed as the beneficiary, they're going to get those assets and apply for those benefits directly. With bank accounts, people can do a POD, and that stands for payable on death. It's also sometimes called a Totten trust. That asset will pass to the designated beneficiary on death. The accounts will be frozen on death, so that money is not going to be immediately available. But once the death certificate is produced, the beneficiary could collect those assets. And TOD is transfer on death, and that would be something like a stock or investment account. Community property owned together will go to the surviving spouse. So that would be, those are examples of assets that are going to pass outside of the will, outside of the trust, directly to the beneficiaries. Now, I had a situation with my dad where he had his trust, and on his trust schedule of assets, he bank accounts and certain assets, which he thought by listing them on his trust were going to be part of his trust. Well, he then made his accounts joint. So legally, that trumps his estate plan. So the joint assets go to the joint owner on the account, not pursuant to the will or trust. So you really have to be careful there. I know sometimes people will put their kids on the accounts and then, but there's 4 kids. And then that child that's on the account has no legal obligation to give any of those assets to any of the other beneficiaries. So word to the wise. Small estate procedures. This is where maybe there's a trust, maybe everything's in the trust, and there's just a few little accounts that the decedent didn't get put in the trust and you want to get them transferred. If they're under those thresholds, so 184.5 in California, 100,000 in Utah, most states have a small estate procedure. Florida doesn't have a small estate procedure, but they have a different procedure. But most other states have this low asset threshold where if the assets in the decedent's individual name were under these cumulative thresholds, that you can produce the successor to the decedent can produce an affidavit and have those accounts poured over. So if there's a trust, the trustee is the one that's going to make the affidavit. If there's no trust, if there's a probate estate, you can't use this procedure, so it all has to go through probate. So this is the catch-all for people with small estates or for people with trust administration that maybe they missed something, and this procedure can also apply to cars and vehicles, again, if there's no probate. If there's a probate, then they need to pass through the probate estate administration. All right. Next, we have final steps for a trust administration. So you really want to make sure that the property is secure, that things are locked and monitored. You're not going to leave real property unattended for extended periods of time. We've had some bad cases where people see a decedent died and nobody's touching the house for a year, and then they'll come in and try to adversely possess it and take the house, or there could be vandalism. So you really want to monitor things, make sure everything's locked, make it look like it's lived in, have people check on it, monitor the property. And then for those of you who want a checklist, I don't know if you can see this, but we have a free report, 7 Steps to Handling Your Loved One's Estate. It goes through a lot of the things that I'm talking about today, but then you can have a PDF of the things that I mentioned today. Then the other things that you're going to want to consider besides safeguarding the property is you're going to want to make sure you're looking at the tax situation, make sure the decedent's final taxes are paid, Married people get a step up in cost basis on death in California. If you're in a non-community property state like Utah, but you originated in a community property state, there's a possibility that state has enacted a law like Utah has that says if you have community property from a community property state and you later move to a non-community property state, we'll let you treat it as community property. Why is this a big deal? This is a big deal because one of the hugest benefits of community property is that when the first spouse dies, all of the assets in the estate get a step up in cost basis. So what does that mean? That means that if you bought your house for $500,000 and now it's worth $2 million and it was community property and it was in your trust, now the basis goes from 500,000 to 2 million. So this is a big benefit to surviving spouses because a lot of times people, when their spouse dies, they don't want to stay in the same big house. Or as we age, a lot of people, I know my mom is currently living in assisted living. Like a lot of people, at some point, it doesn't make sense or they're unable to stay home alone. And you might want to sell the house and move into assisted living where there's activities and food and socialization and nurses and care and like that's a good option for a lot of people if it's financially feasible. So you're going to want to make sure to look at the step up in cost basis, get the appraisals done on any real property, and your stocks and bonds, have your financial advisor or the Schwabs or Fidelities or Vanguards, have the institutions give you date of death cost basis. So all community property steps up to the date of death. So that's a huge, huge, huge benefit. And then you're going to want to hire a team of trust and estate attorney, CPA, financial advisor. You're going to want to make sure you have the right professionals to help you navigate this process because it is a lot of work and there are deadlines and there is liability for the trustee or the executor. So you have legal obligations to make sure you follow the law, follow the terms of the trust, make sure the taxes are paid, or you could be personally liable. So it's a big deal. It's a big responsibility. And I hope this has been helpful. So that's all that I had on my agenda. Just subscribe to our YouTube channel. If you're watching the replay of the webinar, that's great. We've got other recorded webinars that'll be on YouTube. And in 2 weeks, I'm doing another webinar on preparing for the estate tax sunset. So that's the $13 million estate exemption, which is going to be cut in half on December 31st, 2025. So you won't want to miss that. And again, get our free report, 7 steps to handling your loved one's estate. You can just email me. There is a sign up link on our website. You could get it that way and it'll be automatically delivered to you. Either way is fine. But again, it's been my pleasure. Make sure you handle your loved one's estate in the best way possible. And we're sorry for your loss. And if you do need assistance, don't hesitate to reach out for a complimentary 30-minute consultation. I would be happy to discuss your personal situation with you and see if we could be of assistance. Again, it's San Diego and Salt Lake City Trust and Estate Attorney Kristina Hess.